it is a diplomatic, more peaceful means of resolving a case than
gun duels.
Yeah, gun duels, which, we come back to that. That's funny you say that.
That's where it started, and eventually they're like, there's got to be a better way.
There's got to be a better way, right? And so it's still to this day, attorneys in Kentucky are raising their right hands to saying that we will not, nor have we, dueled with guns. So... Hello, everyone. Welcome to the latest edition of Law Lite, brought to you by Foreman Watson Holtrey at 530 Frederica Street, the high-rise ivory tower of Foreman Watson Holtrey. Hope everybody's doing well. PJ, how are you?
I'm doing good. I'm doing great.
Good deal.
So how about you? You look a little worn out.
Well traveled, my man. Well traveled. Yeah, it's been a flurry of the last few weeks for us, but we're doing good, hanging in there. Been all over the place doing mediations and depositions. Had a record streak of mediations, kind of back to back to back. So, landing back here at the Ivory Tower is good for the soul. It's good to be back. We had a little field trip today.
We did. That was pretty interesting. It's been a while since I got to go out and take some photographs of a vehicle.
Photographed a vehicle. Interesting. A telephone pole fell on the top of it.
I was going to say, we've never had one where a telephone pole had landed on top of the car.
After the collision. Yeah. Interesting.
Which I actually just looked at those photos, and I saw them sitting in there on those files. So
yeah.
It was kind of...
Brand new case.
I don't want to say it was neat to have seen the aftermath and then... see the actual damage when it had taken place, but it was interesting because usually it's the other way around. So
a representative from an auto manufacturer was coming out to download the black box today because there was some issue with the airbags. So we got to get out and get a little fresh air and do some background work, right?
Right. He seemed only a tiny bit confused that we were standing out there whenever he got out of the car.
We do our best to confuse him. So.
Mediations, though, going back to that.
Yes. What's up? What's on your mind?
So you've been doing a whole lot of those, and I've never really had a reason to be a part of a mediation,
right?
Because there's really no place for me in a mediation around here for what I do. But
that's not true. I mean, you've done some video presentations that we've used as opening statements.
Okay, yeah. I'll give you that. But I guess what I meant was actually being
a part of them,
a part of it when it's taking place. Right. But I've seen them happening with the mediator going back and forth between the groups of people and that sort of thing. But for people who are listening and may not know what a mediation is, I mean, what is mediation?
Well, as far as mediation's been around for a long time, but as far as the popularity of it, in the last 10 to 15 years, we've seen a huge increase in popularity with regards to the use of mediation as a tool in litigation. So mediation is, as the word says, a mediator is someone as a go-between. A mediator is the word comes from medium or the middle, and so a mediator and a mediation is an opportunity for someone to act as a go-between the parties to see if there is an opportunity to get a disputed matter resolved without going all the way to a trial, either in front of a judge or a jury. And so you see mediation occurring, in advance to a jury trial or in advance to a bench trial. And the reason, there's a lot of reasons. A lot of people have theories on why we're seeing more and more mediations. When I passed the bar exam in 1995 and began practicing law, I really can't recall using mediation in the first I would say about the 7th or 8th year of my practice did I start to see mediation used.
Right.
It used to be that attorneys would hash out settlements between themselves, that they would go all the way to jury trial, and And then, at some point, maybe during the trial, when things really started to heat up, there would become more meaningful discussions about settlement and resolution. But I think as attorneys as technology has changed and attorneys have the ability to handle more cases, that we are busier. And because we are busier, because we have more cases and more clients and more to do, then truly dedicating yourself to taking a lot of time away from your practice to try one case. And you've seen, you appreciate how hard it is for an attorney to get ready for a trial.
Oh, absolutely.
So I think that with attorneys handling more cases, that taking time away to try just one case for 2 or 3 weeks over in front of a jury in the courthouse really can be difficult on the rest of your practice and the expense of it. It costs a lot of money and a lot of resources to try cases. Not only for us privately, where we are investing a lot of expenses in expert witness testimony and exhibits and technology for the courtroom, like projectors and screens and all that kind of stuff, which you help with.
Yeah.
There's that expense, but then you have the court's expense, the administrative cost of it, having bailiffs there, judges working extra hours, clerks working behind the scenes for the judges, jurors coming and paying jurors every day for their service and for their parking and all that. So a jury trial costs the state money. And so now judges have a lot of pressure on them to tell attorneys, hey, get this case resolved for 2 reasons: the expense, but also because their dockets are so crowded because of criminal and civil, that they'd like to push a lot of that civil out so that criminal cases can get attention because of the constitutional right to a speedy trial. So I think it's a combination of all those factors that you have overworked attorneys, big dockets.
Right.
You have judges that are pushing the idea of mediation. And so it's become wildly popular to mediate cases 1, 2, 3 times before you ever get to trial to see if there's a way to get them resolved.
So in short, it's just another part of the settlement process,
right,
to avoid going to trial.
So what happens is the parties will be at some point in litigation, and litigation is nothing more than trial preparation, taking depositions, exchanging documents and things like that to prepare for a trial. And so when you're at that point, there becomes a point where, one side or the other will say, hey, is there any interest here in talking to get this resolved, and should we schedule a mediation?
Right.
And what they're basically saying is, can we agree upon finding somebody to act as a mediator, that we prepare statements or documents for that person to review. We show up at some neutral site, and we let that mediator educate our clients and educate us about what they see as the strengths and weaknesses in our case. So the way a mediation works is, you'll show up, and in advance to the mediation, you'll have sent a brief to the mediator, and it's confidential. The other side normally does not see that.
Right.
Okay. And so you send a nice brief, a video presentation, which we've done in several cases. Instead of sending them a 3-ring binder full of documents, we've sent them a video and said, hey, this is our case, where we've interviewed witnesses and things like that. So your job is to educate this mediator. And let me digress for a minute. You may be thinking, well, who's the mediator, right? I mean, it's one of the things that people say, well, how do you pick a mediator?
Right.
Usually mediators are more senior attorneys who have tried a lot of cases, have a reputation for being reasonable, not hot-headed, that kind of thing. Sometimes it's retired judges, but they're people who they're attorneys who have worked long enough to know how to spot issues in cases and the strengths and the weaknesses. So, the very first thing the parties have to agree on is who to mediate, we're fortunate here. In Kentucky, we have some really good mediators who mediate cases. But yeah, so you agree on who the mediator is. You educate the mediator ahead of time, and that mediator has all your information, has all the other side's mediation information, and case information. And you show up and let the mediator go to work. And I always tell my clients, look, whether we resolve your case today or not is not the big deal. Should we get it settled? Great. If we don't, you always leave mediations a lot more knowledgeable than you went in. And that's our job. As you know, I'm always telling you, pay attention to details, educate yourself. What is this case about? And so a lot of times we go to mediation and we start to learn what the other side is going to say about our case. Not that it's usually a surprise, but it's how they're saying it. It's the way they've put that message into words, and we start to say, okay, we see what they're doing here. We see how they're going about this. And if you don't settle your case, you've come out a lot better prepared for how to present your case. So it's a really interesting process. It's our clients are like, I don't see how you do this, and I've had cases that start at 8 o'clock in mediation, and we mediate until 10:30 or 11 at night and don't get the case resolved. I've had mediations. I've had cases where we've had 3 or 4 mediations before, finally getting the case resolved. So you see all kinds of stuff,
Right. As far as like the setup for mediation, one of the things obviously the parties are never in the same room together, and you have the individual, like you said, the go-between. Yeah. Is there purpose behind that? Because if you were to have both sides in the same room together, there would probably be a lot of disagreements and conflict and things.
It's funny that that's your perception. The reality is that probably 50 to 70% of mediations do start with everybody in one room.
Okay.
It's an opening session of sorts. I've seen these opening sessions be used for all different purposes. Sometimes mediators use them just for everybody to introduce themselves and then quickly put everybody in separate rooms. I have seen the opening session used for what would be an opening statement at trial, where the attorneys speak. I would speak if I do give some type of a more compelling opening statement in a mediation. It's not because I want the attorney to hear it. It's because I want the attorney's client to hear it. I want to talk to that insurance rep or the representative from the hospital or somebody. I want to talk directly to them and let them know what I think about what happened to my client. And on the other side of the table, they will speak not to me, but they'll speak to my client. Because, again, it's an educational process. So they feel like if I can educate Mr. or Mrs. Smith on the strengths and weaknesses of their case and how we're going to, even though we don't, it doesn't sound nice, we're going to stand up against it. It helps my client to hear that,
Right.
Just like I think it helps them. So, yeah, there's an opening session. In having now mediated for about 15 years, like I said, it wasn't really popular in the first third of my career. And I've probably mediated, and I don't want to over-exaggerate the number, but I've probably mediated somewhere between 300 and 500 cases.
Oh, wow.
I've had situations that were kind of close to contentious where I did go out in the hallway and have to have a rather stern talk with the other attorney,
right? Or
that they try to have a stern talk with me, or sometimes attorneys want to talk bad about if there's 3 or 4 parties, they get together and powwow about how unpopular somebody else is that's there.
Right.
But all in all, it is a very well-controlled environment, and it seems to be a whole lot less stressful when I compare it for my clients. I'd much rather put my client through a mediation than sitting through a jury trial. And so it does have its place. I still love to try cases. It's just harder and harder to get them there with the pressure from the courts to mediate cases and to get them resolved. And the financial situation in these cases where clients need money, But, and all in all, it is a very, it is a diplomatic, more peaceful means of resolving a case than the high-spirited jury trial,
right?
So
than gun duels.
Yeah, gun duels. Which we come back to that. That's funny you say that.
That's where it started, and eventually they're like, "There's got to be a better way."
Yeah, there's got to be a better way, right? And so it's still to this day, attorneys in Kentucky are raising their right hands to saying that we will not, nor have we, dueled with guns. So,
all right. So you've done. You said over 300 plus.
I would say so. Yeah. I mean, I would say that. We've been doing, and here's how I come up with that number. Probably for about 15 years, we've been mediating cases. In those first few years when mediation came around, only mediating maybe 2 or 3 a year. But now we're mediating probably close to 20 a year.
Right.
And so
I think you did 300 just in the last few weeks.
Gosh, I feel like it. I've been to every major city in Kentucky mediating cases. If you average 20 to 25 a year now, it doesn't take long to get up over 300, 400 cases. So if I was guessing, I've probably mediated close to 500 cases in my career.
Here's the $1 million question. Do you have any crazy mediation stories?
Yeah, let me think about that. I have a few cases that have just amazing stuff. I have a case where this isn't it's just an amazing statistic.
Right.
The number that was the opening offer in a case that was made to me around 9:00 a.m. It ended up being about 2.5% of what the ultimate case settled for. In other words, the value of the case increased so exponentially over the day that when I got the opening offer, and they're always ridiculous, and so our opening offers, they're out there and opening demands. But this one was so extraordinary that I always tell the story to my clients. I give them the actual numbers, and I say, hey, I'm like, don't be disappointed when the first offer. I one time had a case where this was offered, and then the case resolved for this at the end of the day, and I was like, so just stay the course, So that happens a lot. But I did have a mediation. I had a mediation that occurred in Louisville, Kentucky. In that case, I had co-counsel who I've mentioned on other podcasts before, Lane Seiske, one of my best friends, great trial lawyer from over in Indiana. And Lane had referred a case to me, and he and I went to Louisville to mediate the case. And it was a difficult case. It had some interesting facts about it. Our mediator, toward the end of the mediation, the mediator just started acting kind of funny, okay? And so I was like, I just didn't have a feel for whether or not he was really getting information from the other room or whether he was testing us to see what we would do. And he got to a number in the case, and he said, now, if I can get this number, would it settle the case? And we were pleased with that number. We were like, well, yeah. He goes, well, I've got it. I've got that number. And we were like, well, then, we're done. If you get that number on the table, we're done. He goes, well, I've got that number. And so he came back a little bit later, not long, 10, 15 minutes later, and he said, hey, so that number is going to settle the case, right? And if I'm getting ready to represent that to them, I've got a feedback from them that they're going to be able to pay that. And I said, absolutely. We've already told you can communicate this number to them, all right? So, now think about it, PJ. My client's hearing this, right? My co-counsel's hearing this, okay? And we are assuming he's going in there and telling them what he's telling us, and that he's relating to us what they're saying to him.
Which is kind of the point, correct?
Right. Yeah. Nail, hammer, meet, nail. You've hit the nail on the head. That's the purpose of mediation. So, we say, we finally comes in and he goes, okay, do I have your authority now? Well, like, we've given you our, and then that's why I'm saying, is this acting really weird? So yeah, you've got our authority to resolve the case. And at that number. And so he said, okay, well, we're done. We're finished. We've got it settled at that amount. I almost said the amount, but anyway, he said, you've got it settled. And I said, okay, good. And I said, well, usually what happens at mediations is the mediator will pin something, that works as sort of a to commemorate or to document what's been resolved, and then it gets put into a more formal settlement release or that type of thing. So he said, yeah, I'm going to go down here. I'm going to write it up with them. I'll bring it back to you. Okay. Well, in the meantime, my co-counsel went to the bathroom in this building, right, to use the restroom. And so the mediator comes back down about 2 or 3 minutes later, and he's swearing. He's like, oh, beep, beep. I mean, just swearing. And
expletive deleted.
Yes. He is red-faced, and I'm like, come on. I said, like, let's step out of here. And so we went into, like, the restroom area. Well, my co-counsel was in the stall, and he hears this mediator going, they're not going to back out on me, and like, he's like, they told me they could settle for this, and I'm not going to let them back out, blankety blank blank, like, and I was like, okay. I was like, so they're saying they're not willing to settle for that? I said, no. I asked him point blank, and this was probably the wrong question. I asked him, did you really have authority? I mean, did you hear them say that? Yes, I heard. I can't believe you would imply that I wouldn't. I said, well, I'm not. I'm just wondering. I'm trying to figure out where did this go wrong, because it was so clear that you had that authority. And I was like, I said, so they told you that? Yes, they told me. Now they're telling me they got to make a phone call and that person's not willing. I was like, well, now, then when did that come up for the first time? Here you go again. He said, I can't believe, and I'm like, now the funny part about the story is that my co-counsel is sitting in the stall listening to this whole thing. And so he comes out like in the middle of it, and he's like, so do we have a problem here? And I start laughing. I'm like, do we have, yes, like, it was just such a tension breaker. It's like, so do we have a problem here? And I was like, so lo and behold, we left that mediation without a settlement. The other side said they swore. I went down and talked to them face to face. I said, look, I was like, did you ever give authority for that number? No, we never gave authority. We never told the mediator that. And yet the mediator had represented to us that it was crystal clear that he had. The case was in federal court, so we had to report to the federal judge what had happened. And so eventually, the case did get resolved for that number. But it was about 2.5 months later, after having a little bit more work done on the case and a little bit more information exchanged, and but yeah, we were 100% wrapping up things, putting our books away, waiting for it just to get written up, and he came back and swore up and down that they had pulled the rug out from under him, but they swear up and down. So somebody wasn't
right. So in that situation, what happens? I'm assuming if you do another mediation, is it a completely different mediator that's found?
Yes, I will tell you that I never use that mediator again, because I don't know. I still see that guy, okay, and I want to believe that they did tell him that, and that they were being dishonest with me and being dishonest with him, and it wasn't him. But I also, the whole conversation began when he's like, if I could get them to this, you would take it, right? And then he started taking that language and making it sound as if he had it, and then we're like, yeah, 3 times and so I don't know if he was hoping that they'd get it there, and they were giving indications they would get it there, and they didn't.
Right.
And he was relying upon that, and then they stopped. I'll never know.
The way you were explaining how he was wording it during the story felt a bit sketchy.
It felt funny. And then for him to act so crazy in the bathroom, like he was slamming things around and banging the thing where the paper towels come out. He was like hitting that and like, I can't believe this. Nobody's gonna call me a liar, And I was like, it's all right, calm down.
So much for seasoned and level-headed.
That's right, exactly. And just the one thing that's so important for mediators is that they are very good listeners. There are a lot of ways of saying things, and you've got to be sure of what's being said, and then that has to be exactly what's communicated to the other side. So, yeah, that one was a very testing. You go into a mediation expecting there to be a little bit of contesting things with the other side, and maybe have to step out and talk to them. Maybe they're being, but you don't ever expect to have the mediator just totally lose their cool. I've talked to a guy one time. I had a mediator fall asleep while he was talking in the opening session, and they were like, "Oh, this is going to be a great day."
Right.
But yeah, that's my one experience, and it happened in Louisville. It was about 10 years ago.
Well, it's got to be really disconcerting because it puts you in that mindset where you're like, all right, this is over with.
Yeah, and the client.
And then next thing you know,
probably had already is sitting there thinking, okay, doing the math in his head. Okay, well, we've resolved this, and I've got X amount of dollars that's going to be mine within the next 30 to 45 days. And then you walk in there and say, well, it didn't settle. What do you mean it didn't settle? We were, and then you have to sit there and explain away something you don't even know. I didn't even know what was going on. So.
Was that now? Obviously, you didn't say what the number is, but the number that you all ended up settling with was also the same number that you said that mediator was talking about. So, I mean, I would say though that there might be some truth to what he said.
There could have been
if that number ended up being the same number.
It did, and that's what made me always think that maybe they told him we can't get that today, but we can get it eventually.
Right.
Or
so he may have been misconstruing.
Something got lost in translation.
Right.
Which goes back to what we do every day is so the language that we use in cases, what we tell a client, what a client asks us, we have to pay attention to the language of a case, the language and it's extraordinarily important in a mediation that what's getting communicated between the rooms. We recently, this past week, mediated a case where there was 5 parties involved. There was one plaintiff and 4 defendants, and so there's a lot of you can imagine like the old game that we played as kids, where you whisper in somebody's ear and then they whisper in somebody's ear.
I was literally thinking about that game
What's it
a
called?
few minutes ago.
Like the telephone game or something?
Yeah,
like
I have a different name for it, but it's not it's not PC for today's culture.
And so, again, when you go to choose your mediator, you want to make sure you have somebody that's sharp and I've had mediators that miscalculate numbers and stuff, and you just gotta. So it's a day where you have to pay attention to details, and there's a lot of interesting things that happen. But I personally like mediation. I think it's helpful. I wish that we still had the opportunity to try cases more. But I think those days are gone, honestly. No matter how bad we want to get into the courtroom, no matter it's the economy of it and the pressures that we're getting from the court and some of the rulings too. You want to kind of protect your client from that kind of stuff. So it's a new day and time. And the truth is, it's important for people to understand what mediation is, because if they hire a lawyer in a civil case, more than likely that's going to come up. And so as our clients, if whoever's listening to this, if you've been a part of a case, you probably had mediation be a part of it. Mediation is used in divorce cases. It's used in personal injury cases. It's used in some form or fashion. It's even in criminal cases. It's plea bargaining. But you see so much of it in contract work, and there's a lot of uses for mediation.
Right.
So
okay, and see, that's one of the things I love about this podcast, because I've been here for a little over 4 years, and I've seen mediations taking place, and I'll hear a little bit of the back and forth and the banter and things, but I'm never fully immersed in the process.
Right.
So even this now, I'm learning about these things that are actually a part of my life, almost daily now. But there's still so much to this field that I'm still just learning.
Well, you may remember when we interviewed Davin, and he was like, one of the things that he loves about practicing law is that there's so many pockets and so many different things, and every day is a learning opportunity. And I think that's a great mindset to have. And one of the things I'll say is, even though I've done 300 to 500 mediations, I don't know exactly how many, none of them are the same. They are, no matter how well you prepare, no matter what you expect, no matter what you think you've been through, every mediation is different, And it's the same way with trials. You can be a trial lawyer who's tried, 50, 60, 70 jury trials, and none of them are the same. You can't handle any one of them like you would. I mean, you learn things, you put them in your toolbox, and you say, hey, if I ever need that again, I'll pull it back out, But every one of them is different, So, and it keeps things interesting. So anyway.
Cool.
But yeah, it's been a good couple of weeks. We had a couple of these that did resolve at mediation, a couple that didn't. So we keep right on fighting.
Good deal. How many do you have coming? Do you have any more coming up?
Yeah, we've got a couple on the books. I don't have any more for 2019. We're done mediating for the year. Got a couple on the books for January and February next year, and so we have a few more depositions, and we'll call this year a wrap, man. Cool. This year's winding down.
You'll get a couple nights where you can actually get some, about 6 hours of sleep.
That's right. That's exactly right. So it's time for Ask the Expert. And it's been a while since I've been in on one of these questions because I've been pawning them off to our guests and things like that.
Been passing the buck.
That's right, passing the buck. So what I'll do, why don't I go first today? Okay. And I'm going to ask you one. In law, there is an abbreviation that is sometimes used. It's called ADR. Okay. Do you have any idea what ADR stands for?
Not in the legal field, but ironically, ADR in the film world is where you go in and you re-record dialogue that you couldn't get at the time.
Okay, so
that you were shooting something. Okay. Yeah, it's a re-recording of dialogue.
That's not me preempting your question. ADR is
that's a freebie.
That's right. Yeah. So ADR, the reason I picked that for today, once I saw this was going to jot it down here on my note. ADR is going to be my bonus question. ADR stands for Alternative Dispute Resolution.
Okay.
And mediation is a form of alternative dispute resolution. The traditional form of dispute resolution is a jury trial. Alternative dispute resolution methods are mediation, arbitration. Okay? So when you hear somebody say, alternative dispute resolution, they're referring to things like mediation, like we talked about today.
Okay. I didn't know
There you go.
that.
ADR.
So now I know a different type of ADR.
That's right. That's right.
And now don't ask me what the
acronym?
ADR, what the acronym for ADR is. I always forget but I know what the process is.
Well, shoot me your question. Let's see if I can hit it.
Okay, so I put a list together of several, and I've been trying to figure out which one I want to go with. So
You're always well prepared. I appreciate it.
I'll go with this one.
Okay.
What is an Abbey singer?
Well, Abbey. Is that like British? I don't know. I'm at a loss.
It's based off someone's name, but it's the term for the very last shot taken for the day. Another term is a martini shot. That's
okay. So it's like the last
shot
of video.
The very last shot that you're going to be taking for that production day.
All right. Well, since we're recording Lite here at the end of a day instead of the morning like we normally do, we can say this is an Abbey singer.
This is our Abbey singer.
Lite from Foreman Watson Holtrey. Glad you guys joined us. Hope you all are enjoying it. Tune in next week as we will have another refreshing episode. Me and PJ. From Foreman Watson Holtrey, I'm Travis.
And I'm PJ.
And we love you guys. Have a good week.
Take it easy.